Hello, don't forget to like and subscribe. Always check description for more details. B. Presumptions. Concept of presumptions. 1. A presumption is an assumption of fact resulting from a rule of law which requires such fact to be assumed from another fact or group of facts found or otherwise established in the action. Black's Law Dictionary, 5th ed., p. 1067, citing Uniform Rule 13, NJ Evidence Rule 13. A presumption is an inference of the existence or non-existence of a fact which courts are permitted to draw from proof of other facts. In the matter of the intestate estates of Delgado and Rustia, 480 SCRA 334. 2. A presumption is not evidence. California Evidence Code, cited in Black's Law Dictionary, 5th ed., p. 1167, they merely affect the burden of offering evidence. 1 Wharton's Criminal Evidence, Sec. 64. In a sense, a presumption is an inference which is unless rebutted. 29 Amur 29, Evidence, Section 181. Example, D is the debtor of C, creditor for P1 million payable in 12 equal monthly installments. If evidence is introduced that the installment payment for December has been received by the creditor, a presumption arises that previous installments have been paid. This is because, under the law, the receipt of a later installments of U debt, without reservation as to prior installments, gives rise to the presumption that such installments have been paid. Art. 1176, Civil Code of the Philippines, Sec. 3I, Rule 131, Rules of Court. Inference distinguished from a presumption. 1. An inference is a factual conclusion that can rationally be drawn from other facts. 29 Amur 2d, Section 182, citing Computer Identics Corp. v. Southern Pacific Co. Chi Mass. It is, in other words, one that is a result of the reasoning process. It need not have a legal effect because it is not mandated by law. The fact finder is free to accept or reject the inference. 29 Amur 2d Section 182. A presumption, on the other hand, is a rule of law directing that if a party proves certain facts, the basic facts, at a trial or hearing, the fact finder must also accept an additional fact, the presumed fact, as proven unless sufficient evidence is introduced tending to rebut the presumed fact. In a sense, therefore, a presumption is an inference which is mandatory unless rebutted. 29 Amur 2d Section 181. 2. If X proposes marriage to Y, it may be inferred that X is in love with Y. This is a mere inference and has in fact no legal effect. There are no legal relations established by the mere fact that one is in love. On the other hand, if X enters into a contract of sale of a car with Y, there arises a presumption that the contract was entered into with a sufficient cause or consideration. Sec. 31 R1, Rule 131, Rules of Court, and although the cause is not stated in the contract, it is presumed that it exists and is lawful, unless the contrary is proven. Art. 1354, Civil Code of the Philippines. The presumption, involved in the example, has a definite legal effect. Kinds of presumptions. Presumptions are classified into presumptions of law and presumptions of fact. Presumptions of law are, in turn, either conclusive or disputable. In the matter of the intestate estates of Delgado and Rustia, 480 SCRA 334. The presumption that an accused is innocent of the crime charged until the contrary is proven is a presumption of law embodied in the Constitution. See 14(2), Art. Bill of Rights, Constitution of the Philippines. Art. 1756 of the Civil Code of the Philippines also illustrates another presumption mandated by the law. Under the said provision, in case of death or injuries to passengers, common carriers are presumed to have been at fault or to have acted negligently. An assumption of fact does not arise from any direction of the law. It arises because reason itself allows a presumption from the facts. If A attacks B without provocation, the logical presumption arises that A does not have tender feelings towards B. A presumption of fact is, in effect, actually a mere inference because it does not necessarily give rise to a legal effect. This must be the reason for the trend to discard the distinction between a presumption of fact and a presumption of law. Black's Law Dictionary, 5th ed., p. 1067. Effect of presumptions. A party in whose favor the legal presumption exists may rely on and invoke such legal presumption to establish a fact in issue. One need not introduce evidence to prove the fact for a presumption is prima facie proof of the fact presumed. Diesel Construction Co., Inc. v. UPSI Property Holdings, Inc., 549 SCRA 12. Meaning of conclusive presumptions, Bar 2012. 1. As classified in Rule 131 of the Rules of Court, a presumption may either be a conclusive presumptions juris et de jure, or b. disputable presumptions juris tantum. 2. A presumption is conclusive when the presumption becomes irrebuttable upon the presentation of the evidence and any evidence tending to rebut the presumption is not admissible. Thus, the Supreme Court taught that conclusive presumptions are inferences which the law makes so peremptory that it will not allow them to be overturned by any contrary proof however strong. Datalift Movers, Inc. v. Belgravia Realty and Development Corporation, 500 SCRA 163. A conclusive or a rebuttable presumption is not a presumption at all, it is a substantive rule of law directing that proof of certain basic facts conclusively proves an additional fact which cannot be rebutted. Such presumption rests upon grounds of expediency or public policy so compelling in character as to override the requirement of proof. 29 Amur 2d, Evidence, Section 184, citations omitted. 3. Presumption is disputable or rebuttable if it may be contradicted or overcome by other evidence. Sect. 3 Rule 131, Rules of Court. In the language of Sect. 3 of Rule 131, disputable presumptions are satisfactory, if uncontradicted, but may be contradicted and overcome by other evidence. When evidence that rebuts the presumption is introduced, the force of the presumption disappears. Example, while evidence of receipt of payment of a later installment gives rise to the presumption that previous installments have been paid, yet when evidence is shown that prior installments remain unpaid, the presumption falls. Conclusive presumptions under the Rules of Court, Bar 2012. 1. The following are the conclusive presumptions under Sec. 2. Rule 131 of the Rules of Court, SEC. 2. Conclusive presumptions. XXX(a), whenever a party has, by his own declaration, act, or omission, intentionally or deliberately led another to believe a particular thing is true, and to act upon such belief, he cannot, in any litigation arising out of such declaration, act or omission, be permitted to falsify it. B. The tenant is not permitted to deny the title of his landlord at the time of the commencement of the relation of landlord and tenant between them. 2. The conclusive presumptions under the Rules of Court are based on the doctrine of Estoppels. Under this doctrine, the person making the representation cannot claim benefit from the wrong he himself committed. Phil. Price Assurance Corp. v. Court of Appeals, 230 SCRA 164. 3. First conclusive presumption is often referred to as estoppel in pays or estoppel by conduct. Estoppel. 1. Under the doctrine of estoppel, an admission or representation is rendered conclusive upon the person making it, and cannot be denied or disproved as against the person relying thereon. Spouses Manzanilla v. Waterfields Industries Corporation, Gr. No. 177484, July 18, 2014. Example, persons who assume to be a corporation without legal authority to act as such shall be considered a corporation by estoppel and shall be liable as general partners. Sec. 21, Corporation Code of the Philippines. 2. Under Art. 1431 of the Civil Code, through estoppel, an admission or representation is rendered conclusive upon the person making it, and cannot be denied or disproved as against the person relying on it. Where a party, by his deed or conduct, has induced another to act in a particular manner, estoppel effectively bars the former from adopting an inconsistent position, attitude or course of conduct that causes loss or injury to the latter. The doctrine of estoppel is based upon the grounds of public policy, fair dealing, good faith and justice, and its purpose is to forbid one to speak against his own act, representations, or commitments, to the injury of one to whom they were directed and who reasonably relied thereon. Harold v. Alaba, 534 SCRA 478. 3. Because of the conclusive presumption under Section 2(b) of Rule 131, the Rules of Court sufficiently shields the lessor from being questioned by the lessee, regarding its title or better right, of possession as lessor because having admitted the existence of a lessor-lessee relationship, the lessee is barred from assailing the lessor's title of better right of possession XXX as long as the lessor-lessee relationship between the parties exists. The lessee cannot, by any proof, however strong, overturn the conclusive presumption that the lessor has valid title to or better right of possession to the subject leased premises than it has. Datalift Movers, Inc. O. Belgravia Realty and Development Corporation, 500 SCRA 163, Bar 2012. Effect of disputable presumptions. The effect of a presumption upon the burden of proof is to create the need of presenting evidence to overcome the prima facie case created by the presumption. If no contrary PC roof is offered, the presumption will prevail. Diaz v. People, Gr. No. 208113, December 2, 2015. Disputable presumptions under the rules of court. 1. A significant example of a disputable presumption under the rules of court is the presumption that official duty has been regularly performed. Sec. 31 MI, Rule 131, Bar 2012. For example, in buy-bust operations, the court has usually presumed the regularity of performance of their official duties in favor of members of the buy-bust team. People v. Mendoza, CR number 192432, June 23, 2014. Settled as the rule that, in cases involving violations of the Dangerous Drugs Act, credence is given to prosecution witnesses, who are police officers, for they are presumed to have performed their duties in a regular manner, unless there is evidence to the contrary suggesting ill motive on the part of the police officers or deviation from the regular performance of their duties. People v. Alejandro, Gr. No. 205227, April 7, 2014. This presumption of regularity of court proceedings includes presumptions of regularity of service of summons. It is, therefore, incumbent upon the party questioning the validity of the service to rebut these presumptions with competent and proper evidence. The return is prima facie proof of the facts indicated therein. Masagana Concrete Products v. NLRC 313 SCRA 576. 2. The court, however, emphasized that the presumption of regularity in the performance of official duty obtains only when there is no deviation from the regular performance of duty. People v. Casabuena, Gr. number 186455, November 19, 2014. It is rebuttable by affirmative evidence of irregularity or of a failure to perform a duty. People v. Alejandro, Gr. No. 205227, April 7, 2014. 3. The presumption of regularity does not apply in a petition for a writ of amparo. Under Sec. 17 of the Rule on the Writ of Amparo, the respondent public official or employee cannot invoke the presumption that official duty has been regularly performed to evade responsibility or liability. 4. It is incumbent upon the prosecution to prove during the trial that prior to questioning, the confessant was warned of his constitutionally protected rights because the presumption of regularity of official acts does not apply during in-custody investigation. Trial courts should further keep in mind that even if the confession of the accused is gospel truth, if it was made without the assistance of counsel, it is inadmissible in evidence regardless of the absence of coercion or even if it had been voluntarily given. People v. Camet 256 SCRA 52. 5. The presumption of regularity in the performance of official functions cannot, by itself, overcome the presumption of innocence. Evidence of guilt beyond reasonable doubt, and nothing else, is required to erase all doubts as to the culpability of the accused. Zafra v. People, 671 SCRA 396, 405, April 25, 2012. Also, the presumption of regularity in the performance of official duty does not constitute proof beyond reasonable doubt. It should be noted that the presumption is precisely just that, a presumption. Once challenged by evidence, it cannot be regarded as binding truth. People v. Caranto, No. 198768, March 5, 2014. Reliance on the legal presumption of regularity in the performance of official duty is inadequate to uphold a conviction. After all, the burden of proving the guilt of the accused rests on the prosecution, which must rely on the strength of its own evidence and not on the weakness of the defense. People v. Anad, Gr. No. 205764, February 3, 2016. In case of conflict between the presumption of regularity in the performance of duty of police officers and the presumption of innocence of the accused, the latter must prevail as the law imposes upon the prosecution the highest degree of proof of evidence to sustain conviction. People v. Guinto, Gr. 198314, September 24, 2014. See you next slide. Thank you.